Good afternoon, everyone. The House Judiciary Committee will come to order. We're going to pass over the roll call, but I am going to ask my colleagues to introduce themselves, and the ones on Teams, if you can also introduce yourself. I'm Tim Briggs, Chair of the House Judiciary Committee, and represent the 149th District in Montgomery County.
I'm Jim Rigby, 71st Legislative District. I'm sitting in for Chairman Kaufman.
Hi, I'm Perry Warren. I represent the 31st District in Bucks County, the communities of Lower Makefield Township, Newtown Borough, Newtown Township, Upper Makefield Township, and Yardley.
Representative Kincaid, then Donahue, and then Schusterman online, if you want to do it. And we have Representative Donahue online. There he is. I'm sure we will be joined by a few more folks virtually. I know some of my colleagues are watching it on the live stream. We wanted to get this hearing in. Session days can be a bit chaotic, so I do want to thank everyone for participating on this non-session day on an important issue. Representative Rigby's filling in for Chairman Kaufman. Do you have any quick opening remarks?
No, go ahead.
Okay, thank you. As this is my bill, I'm going to make some opening comments before we go to a great panel of testifiers. For the information of the members, presenters, and those in attendance, this meeting will be recorded and made available along with the testimony to the committee members and to the public as well. Today, we come together to take a closer look at House Bill 2296. This bill addresses the issue of felony murder and how the Commonwealth imposes death by incarceration on certain individuals. A conviction under Title 18, Section 2502B, a person can be sentenced to life in prison without the possibility of parole without committing, intending to commit, or having knowledge that a murder was committed. Currently, there are approximately 1,100 individuals serving this sentence in the Commonwealth. Of this total, 700 people have served more than 20 years of their sentence, with over 300 over the age of 60. We all know the older an inmate gets, the more expensive it can become to care for them. All those costs are borne on the taxpayers. Pennsylvania remains one of only 2 states that mandate life without parole sentences for anyone convicted of felony murder. Other states with similar laws have recognized the injustice of having a rigid felony murder rule and have taken steps to reform their felony murder rule. Today's hearing will give us a better idea if we should reform our system. We need to find the right balance to address this issue. We need to respect the significance of crimes committed, but also make sure our justice system is fair, rehabilitative, efficient, and fiscally responsible. Also, I believe strongly judges have the ability to judge the severity of an individual's involvement in a crime, examine the facts and circumstances of each case, and exercise their discretion in handling down a sentence. I do want to thank a number of partners. Some are testifying. Roxanne has been a great partner. Straight Ahead has helped come up with this draft. And looking forward to hearing all the testifiers today. We will have a better idea how we can move forward on this complicated issue. Before we begin, just a couple of housekeeping members again. Appreciate if everyone could silence their personal devices. Reminder to each testifier to try to keep their comments to 7 or 8 minutes to allow some questions from folks online and here. The first panel, and I want to thank all the panelists. First panel we will hear from is Kevin Ring, Vice President of Criminal Justice Advocacy, and Ashley Nellis, PhD and Co-Director of Research at the Sentencing Project. I see Ashley online. Is Kevin's also online. We also are joined by Representative Pielli, who is on Teams. And if you are ready, Ashley, if you want to go first, you can begin. Looks like you're muted. and a little bit slow on the screen. So Kevin, looks like you're ready to go. If you want to begin, and then we can go to Ashley. If it's on our end, we'll keep playing with it, Ashley. Are you muted, or give us a thumbs up, thumbs down if you? I see the mute sign. Okay, we always have some technical issues at first. There's Ashley's mute is off. Can you hear us, Ashley? Okay, we can hear you. We're going to begin with Ashley, and then Kevin will go to you. I am going to ask Marissa if she could just up the volume a little bit as she begins to speak. Ashley, you may begin. Yep, you can begin. We were just trying to get the volume, and I think if you do it on the bottom of the screen there, that might work. That might be really loud. Okay, you can begin, Ashley. Thank you very much, Dr. Nellis. I hope someone from tech is coming, and it was very soft, but Mr. Ring, if you could do a couple test words. It seemed like some of the members that introduced themselves we could hear. If you could just do a little 1, 2, 3. You're very soft. So if you don't mind just holding tight for a minute, I think the live stream folks weren't able to hear. Someone did walk in, so we're gonna see if this works. If not, we may go to in person and then back to you in a second. Okay, so we switched around the speakers. If you want to do a test 1, 2, 3 again.
1, 2, 3.
There we go.
Can you hear?
I should have listened to Mr. Representative Rigby 10 minutes ago. So can we just calibrate that a little bit, Marissa, just because it was real loud? Okay.
Okay.
There we
There's
go.
other people.
Thank you, Kevin. You can begin.
Okay, thank you. Chairman Briggs, members of the committee, thank you for the opportunity to share our views with you today. I submitted a longer statement, which I'll try to briefly summarize. My name is Kevin Ring. I'm Vice President of Criminal Justice Advocacy at Arnold Ventures. Arnold Ventures is a philanthropy dedicated to improving the lives of all Americans through evidence-based and bipartisan policy solutions that maximize opportunity and minimize injustice. Our criminal justice team is dedicated to increasing public safety while improving the well-being of everyone who encounters the criminal justice system. In short, more safety, more justice. An important way to advance these goals is to use incarceration more sparingly. That is, only when there aren't more cost-effective, evidence-based alternatives to holding people accountable and protecting society. The chairman's bill, HB 2296, raises questions not about the use of prisons per se, but about whether lengthy mandatory prison terms are cost-effective. The best evidence suggests they are not. Even studies that have found a modest positive effect on violent crime rates from some mandatory sentences have concluded that their crime reduction benefits were much lower than other approaches, including more police and violence prevention initiatives. This evidence is consistent with what most of us intuit, which is that the swiftness and certainty of punishment, not its severity, are more effective at deterring crime. If you want to prevent somebody from doing something wrong, make it more likely that they'll get caught. We see this in the well-documented age crime curve, that violent crime tends to be a young man's game. There are always outliers, and there are some people who remain too dangerous to release. But if a state wanted to get the biggest public safety bang for its buck, it would not waste millions locking up 60, 70, and 80-year-olds. Instead of turning their prisons into nursing homes, states, especially those suffering from prison staff shortages, should reduce their investment in lengthy sentences and divert the savings to law enforcement personnel and programs, more technology, and better funded crime labs, all of which are more likely to reduce crime and reduce the number of victims. HB 2296, which would eliminate mandatory life without parole for nearly all people convicted of felony murder, represents one sensible approach to help Pennsylvania reduce its over-reliance on inefficient lengthy mandatory sentences. Other ideas worth pursuing, and that I know the committee has considered, include expanding clemency and medical and geriatric parole. As you know, under Pennsylvania law, a person can be convicted of felony murder if the Commonwealth proves that a homicide occurs while the person was engaged as a principal or an accomplice in the commission of a felony. The statute has two fundamental problems. First, it is overly broad in that it makes no distinction based on conduct or degree of culpability. Second, it requires a mandatory life without the possibility of parole sentence. There are many ways to address the law's overbreadth. A better statute would account for the varying degrees of an individual's conduct and responsibility. You could establish a range of possible sentences to reflect those differences. Subjecting shooters, for example, to greater terms of incarceration than lookouts or getaway drivers could advance the values of proportionality and fairness. Another approach would be to limit the scope of felony murder to cover limited circumstances, including cases where the individual intended the homicide to occur, was reasonably aware that another participant intended to engage in conduct resulting in death, or provided a weapon to the perpetrator knowing that the weapon could be used during the felony. Other states already provide a framework for making distinctions based on the degree and level of culpability. I've mentioned some of those in my written statement. For example, some states provide an affirmative defense for those who didn't kill, weren't armed, or had no reasonable ground to believe that any other participant intended to engage in conduct likely to result in death or serious physical injury. Several states have tightened their laws in recent years and shown that it is possible to correct the overbreadth issues that plague Pennsylvania's law. The second problem with Pennsylvania's felony murder law is that it requires mandatory life without parole sentences. There is no other option. What this means is that there's little difference in sentencing between Pennsylvania's intentional homicide statute and felony murder statute. This unwarranted parity can be remedied by replacing the mandatory life sentence with a more thoughtful range that considers the actual conduct that occurred. Lawmakers must also grapple with the issue of retroactivity, as these mandatory life without parole sentences are inefficient. Applying any reform retroactively would be both smart and fair. At the same time, we recognize that retroactive application can pose significant challenges. Families of victims who died as a result of felony murder were told and have come to expect that those convicted of felony murder will spend the rest of their natural lives in prison, short of pardon or commutation. Lawmakers should lean into principles of procedural justice as they craft reform in this area. Procedural justice ensures that all affected voices are heard and ensures fairness in the process and helps account for the fact that not all victims think alike or have the same views on these issues or on individual cases. Retroactive application also poses some operational challenges, especially in older cases. These cases might require more work from the Commonwealth and Defense Counsel, but it can be done and has been done, and lawmakers should consider providing resources for this purpose. Again, we commend you, Chairman Briggs, for introducing HB 2296 and initiating this important discussion. We believe that smart reform can make the law fairer, as well as free up money to invest in personnel and programs that are proven to actually reduce crime, especially violent crime. Thank you again for the opportunity to share our views.
Thank you. Thank you very much, Mr. Ring. Anyone online, we're also joined by Representative Hohenstein, I see. Raise your hand or interrupt me. Are there any questions for either of the panelists? I have a question for Dr. Nellis, if she can rejoin us. And I do want to apologize to the doctor. You had mentioned recently Colorado and I think Minnesota reformed their felony murder laws. And you also later in your comments mentioned the need to include retroactivity. Do you know how those two states tackle that retroactivity piece of what we're trying to accomplish?
How they handle retroactivity,
Yeah.
you're asking?
Yes.
I don't know the mechanics of how they do, but it's my understanding that both of the states do allow retroactivity. In general, and Kevin can weigh in too, I'm sure, the retroactivity is handled either through resentencing and getting, going before a court again, or through, a moved up parole, or through clemency. But my understanding is that in both of those states, they are allowed to have their sentence reviewed.
Thank you. Mr. Ring, did you want to? I saw you moving around. I wasn't sure.
Oh, sorry.
So the bill, as you both know, deals with it moving forward. Trying to add some, better language, not create it so broad, and deal with the retroactivity piece. And the bill has it going to the parole board. And for the members, they're not present, but the parole board provided written testimony that's in everyone's packets, which is very helpful. So we're just trying to determine the best course forward. I mean, I think it's the parole board gives, you know, the efficiency, you know, the review. We have language in there that they're to you know, take into account the culpability of the incident. But I was just curious what other states were doing. Mr. Ring.
Chairman Briggs, I know, for instance, in Minnesota, already since the law has passed, the prosecutors have gone back to court with some people and they've got resentenced to time served based on the changes in law. So they've gone through court. I think the key is, I mean, this is obviously a decision for the committee and the General Assembly, but I think just having a mechanism to address retroactivity and one that addresses the concerns of victims, you know, as wholly as possible, I think is what's important, is just making sure you do have that mechanism in place.
And I suppose, you know, I agree. Each state is different. You know, it's got sort of places where there's a little bit more dysfunction than others. And so you want to go with the most efficient. I don't know whether it would be possible to allow for either resentencing or parole. I'm not sure of any jurisdiction that does that.
Interesting. Anyone online have anything to ask the panelists? I don't see any hands. Oh, Representative
I see a
Hohenstein.
hand.
There's Representative Hohenstein. I knew we had somebody that could hear us.
Well,
Representative,
you
you're in
invited
order.
me, Chair. I'm Joe Hohenstein. I'm very appreciative of your testimony. Two issues I was thinking about as you were talking. One is what we were just talking about, which is what is a mechanism for the revisiting, for that retroactivity piece. And the way that you were describing it, Mr. Ring, it sounded like most of these things are being done within the context of prosecutorial action and motion, not so much defense motions. What is being seen in this in Minnesota in particular, or any place where this has happened?
I think it does vary by state. I mean, obviously some states, you know, don't even have a parole process to go through. So it really does depend on the state.
Okay. My second question is more one of strategy, which is you noted that there were other more fruitful ways to invest in community safety and in criminal justice, investigations, crime labs, that sort of thing. In places that have looked at or actually passed, you know, revocation of felony murder, how have those types of reforms or additional investments been addressed? Are they done in the same legislation? They done separately? Are they really seen as a package or seen as something that you're dealing with one by one strategically?
It's a really good question. And felony murder, I think, is just becoming under scrutiny more in the last 10 years, for instance. And it stands on its own as an outlier because of its unfairness. This is an old common law practice that is really hard to defend from a sense of proportional sentencing. And so it has passed as a freestanding bill. It has passed, for instance, in Minnesota in a huge omnibus crime bill. So it's passed in different ways. It's hard to isolate that sense that, you know, that same crime bill had other provisions that, you know, protected victim services and things like that. So it's hard and too early to sort of draw any conclusions that by doing one thing, you've seen a reduction in crime. Obviously, it's really hard to isolate that out. I would just say, you know, to you all, as you consider this, that, you know, you're dealing with finite budgets, and you do, you know, everyone says they'll pay any price for safety, but that's just not the case. Usually you do have a limit on what you're going to spend in your anti-crime budget. And spending on these types of sentences that are not warranted and that do not prove to protect public safety is a mistake, especially when there are so many other things you could be doing. So you look at places like Philadelphia where, you know, you're solving half of all violent crimes right? Your clearance rates for violent crimes, for shootings, homicides is low. And so I just think it's important to put all your emphasis on the things that could actually solve crimes, which is more likely to deter people than a long sentence given out randomly, which most people are likely to discount. And so it really is that age-old disparity between swift and certain or severe. And if you can get the swift and certain right, if you catch more people, hold them accountable, you can do less on severity because you don't need to hold people. And it is, as Ashley has said, it loses its value. People age out of crime. It does not have the deterrent effect, and after a while, it doesn't even have the incapacitation effect.
Ms. Nellis, do you have anything that you would add on that issue?
No, I think he hits all of the points. I think one of the important pieces to remember is that, and I'm not sure if this is what Kevin was getting at the beginning, but it made me think, that even if there was no crime prevention piece of it, felony murder is by itself a real problem of fairness in the system. So it is a compensation in some ways, but it's also like, even if nothing else changed, felony murder has to change, just to be a fair system and to be viewed as a fair system. There's a lot of evidence that it's not just that we aspire to have a truly just and fair criminal legal system, but that people see it as that. And when they see it as that, they're more likely to rely on it. And sometimes in crimes of violence and murder and all, we're relying on communities where it's really seeped in. And if police aren't able to sort of communicate with the community and figure out where are the homicides happening, who's committing them, and all that really closes a door, where you could potentially solve more crimes. So it sort of has this cascading effect. So I don't know if that helps, but
it does. I appreciate both of your answers. Thank you, Chair.
Thank you, Representative. Representative Kincaid.
Thank you, Chairman. I didn't have a question, and then your answers to Rep. Hohenstein's question kind of brought something up. So we had a subcommittee hearing actually just a couple of weeks ago talking about deterrence, and across the board it was talking about the fact that it's not severity of punishment, it is swift and certain that really deters crime ultimately. And so I'm wondering if you can kind of speak to the a little bit more about just the ways in which felony murder is sort of not deterring that, and the ways in which we can kind of shift our focus to things that actually do deter crime and make our communities safer.
Well, I would say, first of all, I want to make sure, Ashley, folks know that I do agree that it is wrong on its face, because a sentencing system, among other things, should have proportionality. And so, the classic is sort of like, the more serious the crime, the more serious the time. And yet this stands that on its head, because people who did not intend to commit a serious crime may not have the same culpability or being held liable and being punished in the same way as somebody who did. So that just violates fundamental notions of proportionality that should be bedrock in a sentencing system. But to the issue of proportionality, and the reason I mentioned this, to the swiftness and certainty, and this is why I put this in the context of compassionate release, medical and geriatric parole, is that when the Pennsylvania Sentencing Commission did a study of mandatory minimums, this was years ago, they found that most people don't even know what crimes carried a mandatory minimum sentence, right? So you can't be deterred by something you don't even know exists. And so for most people, they don't know what the punishment is for these crimes. And you add to that they're usually youthful offenders. We know from science that these are folks who discount the future. I say this to anybody who's a parent. You see this in your daily life as to, like, you don't need a 5-hour timeout. You just need to make sure they get a timeout right away. And our system is the opposite of that. It does it exactly backwards. We have randomized severity instead of swift and certain accountability. And so I think this fits into that because it is an example of a long sentence that most people don't think that is going to come with the crime. So it is not deterring them from, going to the robbery that then turns into something different anyway. And so if it doesn't do that, you're not getting any benefit from this punishment that you've imposed ostensibly to deter them from that behavior. And so there's just a lot of things you could do that are just more likely to do that. And there's technology, there's DNA, there's cameras, there's all sorts of prevention and enforcement tools that would be more effective than long sentences.
I think that pretty much sums it up. I'll also just add that, for deterrence to work, you have to be, really working with a full and complete mind. And many of the people that engage in crime are under the age of 25. And so we know from neuroscience that their development doesn't allow them, to really take rational action, especially in heated situations where there's violent crime. And also that, we know from self-report data that a lot of people are inebriated at the time that they commit a crime or participate in a crime. And so they are, less able to sort of recall the Pennsylvania statute, criminal code statute, and what the possible punishments would be for their role in the crime.
Thank you.
Any other questions online or Representative Rigby? I don't see anyone else. You have the floor.
Thank you, Chairman. Thank you, testifiers. A question for Mr. King, or Mr. Ring, I'm sorry. The 1977 ruling Commonwealth versus Sutley, where the Supreme Court held that the legislature cannot, by act of assembly, overrule a judicial system. And that's exactly what this legislation will do. Now, part of this legislation that changes as far as sentencing moving forward, but if we look at retroactivities based on this ruling, I would think this would then become unconstitutional, and I just want to know what your thoughts are on that.
Are you asking about retroactivity? Are you asking about retroactivity?
Yeah.
Yes.
And how to do it, or whether to do it, or it was hard to hear you. I'm sorry.
I'm sorry.
I think that goes for both of us.
Based on a ruling in 1977, Commonwealth versus Sutley, the PA Supreme Court held that the legislature cannot, by act of assembly, overrule a judicial decision. And that's exactly what this would do. So I'm questioning the constitutionality of retroactivity in this bill.
Well, I mean, I'll just take a stab at it as a non-lawyer. That I suppose if the Lee ruling does find that felony murder is unconstitutional, then it would be required for the legislature to, make a fix. I think that's, if you think about it with the juveniles, when Montgomery came down and said it's retroactive, Pennsylvania had to come up with a fix, and it has. It's released hundreds. I don't know. What do you think, Kevin?
No, I think that's right. I really can't speak to the constitutionality, except as you said, there's going to be a constitutional decision, I think in next year. And what the legislature should do is be ready for that. And if certain parts are made unconstitutional, how you implement and enforce that is going to be a question for the legislature regardless.
Thank you both. Thank you, Chairman.
Thank you, Representative. I want to thank both Mr. Ring and Dr. Nellis for participating today. You've been very knowledgeable, very flexible with our tech issues. And I want to thank you on behalf of the members and Pennsylvanians for joining us today. We're going to move to panel 2, which I believe are present. Ann Gant, Dawn Brown Dawkins, who are both family members of victims. If I know Ms. Brown Dawkins was is dealing with some traffic, so I'm not sure if she's present, as well as Lorraine Haw, who's an advocate. If whoever's here of those three names, if you can come and join us at the big table there. Looks like we have all three. So there's two microphones. If you could just go from left to middle to right, and you, ma'am, first. If you just want to introduce yourself, and whoever would like to go first can just. Okay, you on your left, you can introduce yourself and begin your testimony if you feel comfortable.
Okay.
Ready.
I'm Dawn Brown Dawkins. I'm Dawn Brown Dawkins. And today, I would like to talk about my son. My son was a second-degree murder victim as of March the 18th, 2011. My son, Deravius Brown Dawkins, better known as Ray, was a joyous, loving, and helpful 17-year-old boy. He was on the Police Athletic League, PAL, chess team. He had created a babysitting club to help other kids be able to deal with babies and care for them while they were babysitting. He was also a helper in our church youth group. Ray was humble, polite, smart, and well-loved. On the day he became a victim was the first day of his extended curfew. He was on an honor roll. His ROTC drills went well. He wanted to be a Marine like me and his dad. He helped people in the neighborhood and he helped people in the neighborhood, and that was something he did with his friends. That night, he was with his girlfriend, cleaning the garage of a senior and assisting her with various other things that she needed to be done. He was a leader like that. On his way home, two young men decided that they should have his book bag instead of him. His book bag contained a Game Boy cartridges, and a drink container. The only thing on my son's mind was getting home before 9 p.m. because that's when his extended curfew ended. With his earbuds in his ears, he walked his girlfriend home, then commenced to walk homeward himself. At the corner of Oak and Noble, he was attacked. My son had his earbuds in his ears, so he didn't hear them coming. As per witness statements, my son was jumped, shot twice, and left for dead. It took 6 long years to catch these two. Ray was my only son. I have 4 girls left angry, sad, and confused, but make it day by day. In 2011, my son was brutally murdered, and my family endured unimaginable pain and suffering as we grappled with the loss of my son, a brother, a friend, and so much more. Our lives were shattered, and a void was left in his absence that can never be filled. The subsequent arrest and conviction of his perpetrators provided a sense of closure and justice, although partial, for our family. Just knowing that those responsible for Ray's death were behind bars and brought some closure to and peace to our reassurance, and they could not inflict further harm on others. However, the prospect of this new law threatens to undo the little comfort we have found in law in knowing that justice was served. Allowing individuals convicted of second-degree murder to walk free would not only undermine the severity of the crime, but also disregard the profound and lasting consequences on victims' families. Ray's life was unjustly taken, and no amount of time served by his murderers can undo or reverse damage they inflicted upon our family. To release them prematurely would be a betrayal of justice and a disservice to the memory of Ray's life. I implore you to reconsider the passage of this legislative bill and to prioritize the well-being and safety of our citizens. The pain of losing a loved one to senseless violence is a burden no family should ever have to bear. It is our duty to ensure that those responsible are held accountable for their actions. Thank you.
Thank you very much, Ms. Brown-Dawkins, and thank you for sharing about Ray. He sounded like a great young man and a real loss for our community. We will circle back with questions, but if the gentlelady in the middle would like to introduce herself and begin.
My name is Dr. Ann Gant.
If you could just pull it a little bit, I know it's uncomfortable, but if you could just pull the whole thing a little bit closer. The folks online are having a little, thank you. Thank you.
My name is Dr. Ann Gant. Although there may be other survivors who share my thoughts and feelings, I am only speaking from my own experience. I have 3 main points I would like to share. 1, having a long-time career in the social work field, I certainly understand the need for occasional change. Sometimes it is necessary to revisit laws and policies that may be flawed in some way. Number 2, since the murder of my grandson, I now also have the perspective as a survivor. My personal and professional perspectives have been forever impacted by this tragic event. Number 3, so while I am not completely against reform, I am particularly disturbed by a law or policy that would become retroactive. The sentence that is imposed is a huge part of closure. It contributes to having some measure of feeling that justice has been served. Changing that down the road is like ripping a Band-Aid off the wound that has begun to heal. It also makes it easy to lose faith in the justice system. A family is told one outcome at the time of sentencing that they believed would stick, yet it did not. Most importantly, the deceased will never have the opportunity for a do-over. In conclusion, although this particular bill would not apply to my family's situation, I understand the impact on families as a result of my personal and professional experience, including my former role as a victim advocate. Thank you.
Thank you very much. And process of limitation, Ms. Haw, if you could introduce yourself and provide your testimony. Thank you.
I don't think I'm going to need the mic too close. Hi, my name is Lorraine Hall, better known as Miss Dee Dee. I want to say, first of all, condolences for y'all losses. And like them, I also have a young brother that was murdered by gun violence. But I'm also here because I have an only child who's been incarcerated for 30 years on second-degree felony, and he didn't kill anyone. And so I can just give you the perspective of a mother and the hell that I've been living since my son has been incarcerated. I didn't get a chance. My son's chances were already cut when he was young because he had an addict for a mother. So he didn't really have anybody there for him. But I used to feel how they feel. When my brother got murdered, I hated everybody. I wanted the person that murdered my brother to be electrocuted, to be killed. I wanted his family to feel what my family was feeling. I wanted them to hurt the way we were hurting. And it took me a minute to realize that the feeling and the anger and the bitterness that I held inside was hurting me. It wasn't hurting the person that did the killing of my brother. But I came to my senses, and it's only through the grace of God that I was able to, in my heart, forgive this young man for taking my brother, one of my younger brothers. And I'm glad that I did, because I started to live life, and lo and behold, it seemed like it prepared me for when my only child got incarcerated. I can't sit here and tell you what it is to go anywhere with your son, because I've never experienced that. I was too much into my drugs. So my son was truly raised up in the streets. So he never had a shot. But I know that my son is not the crime that he was involved in. You know, he was never a bad kid. He just got caught up in our communities where, you know, you have friends and they weren't the best of friends. And when you were the youngest one, then you followed the eldest one, whether it be right or whether it be wrong. You know, and they didn't know what it is to tell them that friend's not a good friend. But my son became a man. He was only 18 when he got arrested. And my son will be 49 in January. And the reason I say I go through hell, because I can't wake up and tell my son how much I love him. I have to wait for a 15-minute call. And at that 15 minutes, 3 or 4 times, someone's reminding me that it's a call from a prison. I have to go through searches just to go see my son. I can't just go around the corner and visit him. It takes me 3.5 hours, where it used to be 4.5 hours, till they moved them 1 hour less, closer. And the things that you have to go through, the money you have to spend in there, it's crazy, but I'd give my life in a heartbeat to trade places with him, because I've lived life already. Be it was wrong the way I lived it, but I know that I believe in second chances, because as my son, I've experienced incarceration, and I finally decided to, you know, I have to get my life together, not through rehab, not through anything like that, but through the grace of God. And I got my pardon signed by Governor Wolf when he was in office. I got my records expunged. I'm a student. I'm in my second-year student in Community College of Philadelphia, going for a degree in criminal justice. You know, and I do all of this to show my son that we're not who people say we are. We can be productive citizens. We just have to put our part. And that's all I have to say.
Well, that was a lot. Thank you very much. Are there any questions for the second panel from in person or virtual? All I want to say is all three of your stories are impactful. What we are trying to draft is to be able to find those nuances in that case, in the instant, to make sure that the level of culpability is reflected in the sentencing. The way the bill is the way the law is now, it doesn't matter if you were the actor who pulled the trigger, or if you were in the parking lot in a car getting ready to drive your friend out, picking up a pack of cigarettes, and not knowing what the friend did inside the store. I think that is innately unfair. And what we are trying to do is to find those nuances to allow the judge to provide the most suitable sentence. So I think what each of you shared is helpful to us to get to that. Retroactivity is something that there's folks who are serving a lot of time now that shouldn't be there for, you use the term premature. Right now, they're there till they die. So what anything premature is less than dying in incarceration. I have a hard time with that concept. But I do want to thank you very much for being here. If there's any comments online, raise your hand. Thank you, and Chair Rigby for some quick comments.
Thank you, Chairman, and I too thank the three testimonies today. They were moving, they were heartfelt, and understand where each one of you are coming from. Ms. Gant, you made the statement that sometimes it's necessary to revisit laws and policies that may be flawed in some way, and I think in a way that's what the chairman's bill is trying to do. But I go back to the retroactivity and your background. I imagine that your role as a victim advocate, you've met with families and family members of second-degree murder victims on numerous occasions. And I'm just curious, how do you think those families would feel knowing that if this legislation would pass with the retroactivity in it, what would that mean to those families?
I think first I'll say what I said at the beginning of my statement. I know that I can't speak for how all victims would feel, but maybe more of it I would share is what I felt sometimes inwardly, that sitting with the family and them hearing this particular sentence, and then myself even sort of wondering, like, will this be what ultimately sticks?
And Ms. Dawkins, you had mentioned too, your feelings on this if this were to be reversed and your son's murder would be released, your feelings.
I'd be flaming mad because my son cannot wake up in the morning and walk and say, "Hi, Mom." He cannot wake up in the morning and go outside. He cannot do things that people alive do. He was shot twice. He is dead. There is nothing that can bring him back. And I feel this for the shooter and the other young man that jumped him, because he couldn't have got shot if they wouldn't have jumped him. Thank you.
Thank you, ma'am. Thank you. Thank you, all three.
Thank you very much. Our next and final panel will be Kelly Callahan, Executive Director of the Pennsylvania District Attorneys Association, Celeste Trusty, Deputy Director of State Policy for FAM, as well as Roxanne Harrell, Legislative Director for Straight Ahead. I'll give you all a little bit to get situated. So why don't we begin with Ms. Callahan, and then Ms. Trusty, and then Ms. Harrell. Ms. Callahan, you have if you could just pull it a little bit closer. I know it's probably uncomfortable, but if it needs to be closer, I'll interrupt.
Okay, there we
Great,
go.
thank you.
Okay. Thank you, Chairman Briggs. Also to Representative Rigby, who is sitting for Chairman Kaufman today. We appreciate the opportunity to weigh in on this important subject as you are evaluating our current felony murder statute in Pennsylvania. I am the Executive Director of the Pennsylvania District Attorneys Association. Excuse me. And I'm also a former elected district attorney, having served in Cambria County for 10 years as DA. In that time, I have prosecuted violent individuals, including cases of second-degree murder. So under Pennsylvania's law, I just want to be clear that people that are convicted of second-degree murder have committed serious violent crimes where victims are targeted for one reason or another. Maybe it's because they control money that these people want, or they are looking for some type of forced sexual act, or revenge for some reason. And some of the victims of second-degree murder are known to the perpetrators, but oftentimes strangers, complete sympathetic victims that are just trying to do their job or work in a bank or as a cashier in a store are targeted and become victims of not only the underlying felony, but also the death that results. And one thing that I want to be clear on is that second-degree murder, when you seek it, is very limited, and it's limited to certain felonies, and I believe there are 6 of them, and they are robbery, arson, kidnapping, burglary, rape, and involuntary deviant sexual intercourse. And on the last 2, rape and involuntary deviant sexual intercourse, it's not every section of those 2 crimes that apply to second-degree murder. It's only the sections when it is by force or by threat of force. And that is the only way that you can seek, as a prosecutor, a second-degree murder charge or conviction is if one of those felonies apply. And many times, the cases are divided between principal or accomplice. So to be convicted, you can either be the main actor or principal in the killing or an accomplice. And many of these cases that you're looking at in the figure that you've mentioned of about 1,100 serving time now for second-degree murder are the killer. It's not always that accomplices are charged in the acts. So many times it's a one defendant case and the defendant is the killer. And sometimes there is more than one victim. So in some scenarios that you will see, the killing involves multiple people. I just want to talk a little bit about prosecutorial discretion and how some of these charges weigh out once they are charged. So first of all, murder in Pennsylvania is, you can charge different ways. So some prosecutors' offices, mine when I was district attorney, we charged a general offense of criminal homicide, which would include all 5 forms of murder, which are first degree, second degree, third degree, involuntary manslaughter, and voluntary manslaughter. But as there's not uniform over the state, some prosecutors will choose to identify exactly what classification of murder that they are charging. But one of the reasons that I always felt criminal homicide was appropriate is because the case doesn't end, or the investigation doesn't end when charges are filed. And in many ways, it is the beginning. And you have access to a lot of pretrial process that you go through, to include the preliminary hearing, exchanging discovery, motions being filed. And a lot of times during this process, defense attorneys who are representing people charged with second-degree murder will approach you with some mitigating factors that maybe were not clear at the time of the investigation because of the constitutional rights that are so important to the accused, who have a right to remain silent. But sometimes as it unfolds and information is shared with you, you can account for what you're going to do in the case. And this might be someone who decides to cooperate, who maybe is the accomplice, not the main principal, or some of these factors that maybe negate complicity of a person. And finally, age. You know, it is a consideration for prosecutors, the age of the perpetrator, in light of the steps that were taken, even as an accomplice, knowing that the sentence is a life sentence. But as this plays out, some individuals, despite, you know, plea offers or you know, exchanges, exercise their right to go to trial on this offense, which is paramount for our justice system. At the time of trial, jury instructions are given, and I just want to make sure you understand that when there are charges brought, that the court advises the jury, if it's a jury or the judge himself or herself, looks at what degree of murder it is, meaning the jury is instructed, you start with first-degree murder. If it meets the definition of first-degree murder, you're done. You don't go to second-degree murder. If it then meets the elements of second-degree murder and you're convinced that it does, then you don't go to third-degree murder, and as it goes down the line. So there are times where prosecutors charge both first and second-degree murder, or if it's a general criminal homicide charge, the jury is being charged on both. But and my point being that sometimes your theory, the theory of the case, you might believe lends itself to first degree, but conviction might come back as a second degree. And that could be for different reasons. When the jury is instructed, the judge in the jury instructions actually identifies second degree murder as a lesser offense. So juries are not permitted to know the sentence that comes with the charges. So in some ways, we think maybe some juries compromise, thinking that second would be a lesser degree of first. But I just wanted to make sure you understood that. Also, there are times when the Commonwealth is not 100% when accomplices are working together, who the actual killer is that deployed the deadly force, because they're working in concert. And many times the defense at trial will be, he did it or she did it. They're pointing the fingers at each other, which naturally lends itself to a second degree charge to have the trier of fact sort that out. I just want to mention retroactivity, that we are of the agreement that it would be inconsistent with case law and precedent if you would change this second-degree murder sentence to apply it retroactively. Also, the court response would be significant. It would burden the court system, and there would have to be some kind of process by which these cases would be looked at and reviewed. And finally, that you consider the trauma to the victims who, in some of these cases that are decades old, will have to relive what they experienced. And these are victims who are sons, daughters, brothers, sisters, parents, that are going to be put back through the system. And through our Victims' Rights Act, have many times provided input on pleas. And there are individuals who are in this number that are doing this time who have entered knowing voluntary pleas to second-degree murder for whatever reason, whether they're accepting responsibility or it's been considered, hey, we were seeking first degree, but, the plea agreement will allow you to plead to second. So as to that, there should be some kind of process for considering that, and retroactivity would really be inconsistent with case law. And finally, I just want to say that regardless of where you go from here, that a life sentence in many of these cases is warranted and is appropriate. These are some of our most violent, heinous crimes, as I said. Oftentimes, they're complete strangers who are in the wrong place at the wrong time, and that these individuals are committing not only the underlying felony or attempting to commit it, but also escalating their conduct to homicide because they are taking a life. And I would just suggest that any reform that you consider should be up to and including life, because it is appropriate in this situation. And I think that's it. Thank you for allowing me to address you.
Thank you very much for your testimony. Ms. Trustee.
Good afternoon, Chairman Briggs, Representative Rigby, filling in for Minority Chairman Kaufman, committee members, staff. It's all really wonderful to see everyone today. And it's an honor to be included in today's informational hearing on HB 2296, which would reform Pennsylvania's archaic second-degree felony murder sentencing requirement of mandatory life without the possibility of parole. My name is Celeste Trustee, and I am so proud to serve as Deputy Director of State Policy for FAM and to have previously served as our Commonwealth as Secretary of the Board of Pardons. I want to thank Chairman Briggs for introducing this critical piece of legislation this session, and also former House Judiciary Committee member Representative Dan Miller and Committee member Representative Rabb for introducing felony murder reform legislation last session. Most importantly, I want to recognize our incredible community members who have returned home after incarceration and continue to exemplify the power and the beauty of second chances, and to honor the many, many people who are still fighting for their opportunity for a second chance. Their contributions and presence in this work are often overlooked, but they have laid the groundwork for over decades to get where we are today. I'd like to ask those of us who have come to show support for HB 2296 to please stand if you're able. This powerful group of community members represents incarcerated loved ones and community members who are unable to be here in prison, and people who have been liberated from incarceration and are now free to help carry messages of hope and redemption. People like Francisco Mojica, who was granted clemency after a second-degree felony murder conviction and is an incredible community member in Pennsylvania. And the support for felony murder reform extends far beyond this room, with an overwhelming 79% of Pennsylvanians in support of changing our current mandatory life without parole sentence for people convicted of second-degree felony murder. It's hard enough to get 79% of people to agree that the sky is blue, but to have 79% of our community members in Pennsylvania agree that we need to reform how our system doles out indiscriminate, blanket, mandatory death by incarceration sentences for felony murder convictions, that's huge. 79% should make everyone want to pay attention, no matter where in the Commonwealth your district is located or what party you belong to. I want to spend the rest of my time with you today by sharing the story of my friend Ezra Bozeman. And I'm going to try to get through this without crying. This is my friend Ezra, who you'll see in some pictures in front of us. Ezra was just 19 years old when he was arrested in 1975. And although Ezra has steadily maintained his innocence, he was subsequently convicted of second-degree felony murder by an all-white jury in Allegheny County and sentenced to the mandatory requirement for this conviction, which is life without the possibility of parole. At just 19, Ezra was judged. But instead of suffocating under the weight of this oppression, Ezra became a bright light in the darkness that the system tried to bury him under, and he shares that light with everyone he meets. Ezra truly exemplifies a grounded strength, and throughout his nearly 50 years of incarceration, Ezra has shown a desire to continue to grow, branch out, and bless others with his deep wisdom and his grace. While incarcerated, Ezra became president of the Lifers Association. He's a certified peer specialist. He was a resident on the honor block for so many years, and he mentored countless people, leaving a permanent positive mark on so many lives, including my own. This is just a stack of a small amount of certificates that Ezra achieved and earned while he was incarcerated, serving a life without parole sentence. Ezra did incredible work during his nearly half a century of incarceration, but he was denied relief through clemency a few years ago while I was Secretary of the Board of Pardons. I was crushed. Even so, Ezra still persisted and served his community. Ezra recently suffered a string of medical issues that led to him experiencing near complete paralysis and being transferred to a prison hours away from his home prison at SCI Chester, where Ezra had been living. Ezra petitioned for a medical transfer under Pennsylvania's extremely narrow compassionate release law, a petition that was supported by Governor Shapiro, but was unfortunately opposed by the Allegheny County District Attorney's Office, causing an additional delay prior to the judge finally ruling in Ezra's favor on May 20th. Unfortunately, Ezra was rushed to the intensive care unit the night before the judge's ruling, yet another tangible and cruel impact of the system's unwillingness to extend compassion, even in the most dire of circumstances. Luckily, I was able to visit with Ezra this week and share in the joy of his newfound sense of freedom with his beautiful fiancée, Christine, by his side. HB 2296 would have allowed Ezra the opportunity to seek relief after serving 25 years in prison, and the opportunity to utilize all of these incredible certificates, his education, and his lived experience to pour into the outside community as much as he has poured into his prison community. But instead, Ezra served almost 50 years of a life without parole sentence and was only granted relief after suffering nearly complete paralysis, and even that was a fight. And even still, without the ability to move his body, our system requires him to wear an ankle monitor. The struggle to inject compassion and mercy as a balance to the legal system's obsession with unending punishment simply should not be this hard. How much more can our system try to squeeze from this man? Is this really how we want to be remembered as a Commonwealth? Even through all of this, Ezra's spirit and fight remain strong. Ezra Bozeman is a better human being than I am. He's honestly a better human being than most of us. When the public narrative and opposition often portrays the most heinous examples as the norm, I ask that you remember Ezra. I ask that you speak his name, think of his sweet face, and share his story to counter the harmful narratives that perpetuate this lust for punishment and overlook the power of redemption. Each and every one of us in this room has made mistakes, and we are more than those mistakes. When you look around this room full of mistake makers, you see us as more than our mistakes. You see lawmakers, you see legislative staff, you see attorneys, you see advocates, you see family members, and you see friends. And outside of this room, stuck inside our prisons, are people just like all of us, mistake makers. And they are also so much more than their mistakes. Last month, hundreds of us rallied here at the Capitol to end death by incarceration in Pennsylvania, and the theme of this year's rally was "We Are More." The amazing folks at Let's Get Free, the Women and Trans Prisoner Defense Committee, collected powerful statements from people serving death by incarceration sentences in Pennsylvania's prisons. And I'd like to speak a few of their powerful statements into the record as I close out my testimony today. We are more than a moment in time, and so much more than our crime. We are captains of the ship called redemption. We are capable of accountability and transformation. We are the tools meant to help repair our community. We are simply human. We are love. Ezra is more. He is a leader, a fiance, a mentor, and my friend. I encourage the committee and the staff to visit people inside of our prisons. I guarantee that you will find there are so many people like Ezra who are more than their conviction. They are community members awaiting their opportunity to pour into our communities if only given the opportunity to do so. HB 2296 goes a long way in honoring our Commonwealth's core values that are emblazoned on the state flags that fill these halls of power and are behind each one of your official portraits. Virtue, liberty, and independence. These are core values that those who choose public service should strive to uphold constantly. Thank you so much for your time and for considering FAM's input on HB 2296.
Thank you very much, Ms. Trustee. Next will be Ms. Harrell from Straight Ahead. You can begin when you're ready.
Yeah, thank you, Representative Briggs. Good afternoon, Chairman and members of the Judiciary Committee. My name is Roxanne Harrell, and I'm the Legislative Director of Straight Ahead. I would also like to give a quick shout out to our colleagues at Amistad Law Project, who are close partners in this work and will continue to be going forward. I've submitted my written testimony for the record, and I'm going to paraphrase it in some ways, but I do want to speak to, I've been doing this work for the last few years, leading a campaign to end death by incarceration in Pennsylvania, and I do want to speak to the Sutley question real quick that Rep. Rigby asked a little while ago as to the constitutionality of the bill. And so, like, the Briggs bill, actually, it doesn't change the sentence, it changes the manner in which a sentence is enacted, basically. And so under Sutley, there's a pretty strong argument that is allowed. I can send you a legal memo if that would be helpful. We have one written, and it can provide you with more information. And so after the hearing, I will do that. But under our interpretation of Sutley, the bill is constitutional. And that's not in, doesn't take into account also, like, the Supreme Court is about to consider the constitutionality generally. But even absent that, like, we believe it's still constitutional. So, we've heard a lot of experts speak already. I can, talk about stats and things like that. But, I do want to speak to something that you don't often hear about. I think, this is an issue that's not easy to consider, right? There are two sides and, like, multiple sides. It's very multidimensional, and, people feel very strongly, and, all of those voices are valid, right? And, like, even when, I know I'm on the side that is supportive of this legislation, but, even in our work, we are very intentional about engaging with victims. We have somebody on staff who's a survivor justice advocate for that very purpose, because we know that that's part of the work. And the reality is that, people who come from communities that are most victimized are also the communities that are most affected by mass incarceration. And so this wall that we put up between victims and people who commit harm or cause harm, it's not really real, right? In a lot of these communities, a lot of these, the DA's Association talked about, like, people being strangers, but a lot of the times that's not the case. It's like these people know each other, they're in the same communities, they're in the same, sometimes in the same families, in the same neighborhood. And the question of accountability and harm is a lot more complicated for these people. And this is, what I'm saying is that this is the majority of people who are inside Pennsylvania prisons and who are most impacted by the system that we have in place currently. And often it's people, young people, who are coming up in low-income communities, who don't have resources, who make bad choices, but, who possibly could make better ones if they came from a different place, right? And so I want to say that, and, like, it's a complicated issue, and, like, I hope that we're able to come to a place where there is compromise, and, like, we're not lacking in compassion. Like, just because there's justice doesn't mean there's a lack of compassion. And I believe that our justice system, can include compassion, right? Because, I'm going to speak to something that perhaps we don't hear about a lot. And, like, when we talk about this issue, you often hear about the most extreme cases as justification as why change should happen at all, right? But the reality is that those cases do not represent the vast majority of people who are inside Pennsylvania prisons serving these types of sentences. And the law as it is does not account for circumstance, right? It does not account for what happened. It does not account for the age of the person. It does not account for someone's ability to grow and change and to be redeemed and to become a better person. And I think these are all things that we have to consider, right? So I'm going to talk about, some of those stories that maybe we don't hear all the time, like some of the stories of the people that we know who are, hundreds of people. We know hundreds of people who are out here already who were convicted as children, but who are out here doing good work. The majority of the people that we know that have been released of both first and second degree murder, by the way, who were serving DBI sentences, are people who have gone back in their communities and are trying to do good work, trying to make up for the wrongs they have caused to their communities. And the reality is, a lot of those people are still missing in our communities, and there's a gap. We talk about public safety and we talk about wanting to keep communities safe, but how is the community supposed to rebuild itself when we permanently remove their members and never bring them back? And so I want to talk about some of these community members that are missing and some of our friends. And so I would like to tell you about Matthew. Matthew has a close family friend in the audience today. And Matthew was incarcerated at the age of 18 years old. He's been in prison for 25 years. He was convicted of second-degree murder. He was accomplice in that crime. Although he didn't murder anyone, he was present during the time of the crime took place, which resulted in him receiving a life without parole sentence. We like to call that death by incarceration, just because it more accurately reflects the reality of the sentence. But Matthew comes from a poor community, a community where there is poor educational systems, drugs. He came from a single-parent household. There's a large population that's in prison. Matthew is also someone that has lost people to gun violence, both family and friends. And but while in prison, Matthew has made the best of his time there. He's been a positive and productive influence on his individuals and peers. He's given back to his community in many ways by leading fundraisers. Many people might not believe this, but a lot of people inside prison try to do good work for the community, including for victims. They try to do work fundraising for victims, the victims' families, and they also have a day of responsibility where they, can acknowledge the harms that they've caused. And, Matthew has been involved in these types of things. He created a program called the Real Rap Restorative Art Program, where he provides lessons to men on how to navigate challenges and to use their skills in creative and productive ways in order to bring back to the communities. He's taking accountability for his actions, and he deserves to be free, right? Or a chance, at least, right? I also want to talk about something more difficult, the people that we've lost along the way, Earlier this year, we lost a great friend to our movement called Dawood, and it was a hard loss for many of us, but Dawood was a mentor and a friend to a lot of people. He mentored a lot of people inside, changed the lives of a lot of young men who were going the wrong ways. He took a passion in educating and mentoring, and he was someone that was actually denied commutation a couple years back. And but he was somebody that was a prolific writer. He was somebody that was a student of restorative justice and transformative justice, somebody that wanted to change the world for the better, and somebody who was out would have, right? But he was limited by his incarceration. Unfortunately, Dawood passed earlier this year, but he also deserved a chance to be free, but we lost him before he had that opportunity. Finally, I would like to talk about Charles. Charles is still incarcerated at SCI Phoenix. He's been there for 40 years. And he's probably one of the kindest and most gentlest individuals I've ever met, right? And at his time in Phoenix, he has managed to co-found a restorative justice program and has facilitated many workshops for people both inside and outside over the last couple decades. He's also someone that seeks to make the world better. He's somebody that, dreams, and somebody that seeks to right the wrong that he's done in society. I mean, for those of you who don't know what restorative justice is, it seeks to bring the people who have caused harm and people who have been harmed together so that, there can be like more holistic healing and understanding between those parties. And, Charles is the person that teaches this to people coming inside prison, but also to incarcerated individuals in prison. I had the opportunity of visiting SEI Phoenix recently to attend one of Charles's workshop. It was during Victims' Rights Week. It was a call to end harm. And during that, there were about 27 incarcerated individuals that were part of this workshop. And, many of them serving death by incarceration sentences, so convicted with a mix of probably first and second degree murder. And for me, it was transformative in many ways, right? And these men who have like little to no hope of ever being released, yet, we spend the day like getting to know each other, sharing with each other, dreaming about a different world and how we can make a safer and better future for everyone. So while on the surface these men, don't have much to be hopeful for, there was still much hope present in them, and I thought that was really powerful. And in my opinion, there was no one there that day that should still be incarcerated, right? These were really thoughtful, sweet men who were really striving, to make society a better place, who acknowledged what they had done, who wanted to right that wrong, and who are limited and constrained by their incarceration. But yet, they've been written off by society as deviants and quote-unquote monsters and all of these things. But when you go in and meet these people for yourself, it's, it couldn't be further from the truth. I left that day wishing that more people could have a similar experience. I think it's very rare that we have authentic dialogue and experiences with people who are currently incarcerated, and especially people in power like yourself, right? I do want to, extend an invitation for the Judiciary Committee to go in and take one of these workshops to interact with these men. And if that's something that you're interested, it's something we can arrange, because I do think it can be important in a lot of ways to see people differently, especially as you consider a bill like HB 2296, to see like the population you're actually impacting, right? So you get to know these men. So they're not just a number or, a newspaper story or like what they did in their youth, which, we know that, a lot of people who commit violent crime do it before the age of 25. Before their brain is fully developed, and these men, they've been there for 20, 30, 40, 50 years. I met an 87-year-old man, and I was just like, I was shocked. And I was like, what are you doing here? I was like, and he had the biggest smile on his face. He was just like so happy to be able to do this workshop, And, I think incarceration is designed to make people invisible after we lock them up in cages, and we dehumanize people and make them out to be monsters. And this makes it easier to hold assumptions about people and who we think they are, and it discourages us from exercising compassion to see who they truly are as a whole person and a human being. And but people like don't cease to be human just because they're incarcerated. Yes, they've made very terrible mistakes, and I'm not saying there shouldn't be consequences for harm, right? No one's saying that, and even this bill is not saying that, right? Like this, it allows for retroactivity, yes, but there's a process, it's not just like we're letting everyone out. They still have to go through a very lengthy parole process in order to get out. And, that includes, like you said, circumstances of the crime, culpability, input from victims, a victim's family. Like those are things that are all included in the parole process. And we're not saying that there shouldn't be, that should be changed, right? And as far as backing up the courts, that's why we believe it should go through the parole board, not the courts. We have that same fear that it would be backed up, and we've seen that with the the juvenile lifers, that some people's cases are still being heard and haven't been heard because of that, right? And so that's why we believe parole is the best mechanism to do that. And yeah, so and I do want to close with some words with that someone from SCI Muncie wrote, Terry Harper. Celeste talked about We Are More. That was the theme of the Cabby rally this year. And we got some really beautiful responses because I believe that people are more than the worst thing they've done, that they're more than one moment in their life, and that we should seek to see people holistically. So I'm just going to read these words real quick. We are more than people sentenced to die in prison. We are people existing to live our renewal, not die in our failures. We are more than people sentenced to die in prison. We are people dying to survive a system built on fear and retribution. We are more than people sentenced to die in prison. We are people living to show our worth. We are more than people sentenced to die in prison. We are people dying to live in a world of forgiveness. By life, by time, and by every obstacle we faced head on, we are not our crime, sentence, or number. We are so very much more. We are survivors, survivor of our bad decisions, reckless abandon, and the labels those things have put under us. We are conquerors of our shortcomings, coordinators of a new game plans, captains of the ships called redemption. We work, educate ourselves, create positive content, and nurture and guide others while navigating a system that's not designed to help us become the more they expect, the more they demand, or the more we continue to achieve. We are every title of every human being that exists. There's more. We are people who messed up. We are making considered efforts to ready ourselves for whatever kind of tomorrow we are granted. And we need our forgiveness first, your constancy most, and your support overall. Thank you.
Thank you very much for all of your testimony. Any questions online, raise your hand. Ms. Harrell, if you could provide both of us the memo, and we'll share it with all the members. I do appreciate that. So I have a question for Ms. Callahan. You had mentioned first degree, second degree. Sometimes it's a plea to second degree because of perceived easier, I'm not going to put words in your mouth. Could you remind me what the charge would be for first degree, like what the sentence would be?
So the sentence for first degree and second degree is life. Or for first degree, you also have the ability to seek the death penalty if it would apply, or any of the aggravated circumstances would factually be present in your case.
So an individual who would be concerned about execution would plead to a second degree? Is that, I mean, that would be the difference, right?
Well, I mean, I can't really speak for why, the individual may plead, but.
Well, you said they would plead for a second because it was a, I could read it.
No, I mean, I think there would be situations also where death would not be being sought, where an individual may wish to take responsibility and plead to second rather than first. Reason being is it's conceptually considered a lesser degree of murder. Even though the sentence is the same, the way it's worded in our law is that it's a lesser degree of murder.
Anyone have questions? Representative Rigby.
Thank you, Chairman. Thank you to the three testifiers again. And if you forward that information, I'm not an attorney. That's why I ask a lot of questions, so thank you. I'm not so sure, though, that Ms. Dawkins would agree with a lot of this. Her 17-year-old son didn't see a 21st birthday or a 30th birthday or a 35th birthday. And I think it might be a hard sell when speaking to some of the victims' families. But Ms. Callahan, you had mentioned in your testimony that if retroactivity would happen, could create a backlog in the system. Just explain that a little bit, please.
Sure. So this occurred, several years ago when it was a judicial determination on juvenile lifers, juveniles who were convicted in doing life, and those cases had to be reviewed. So it puts some onus on the counties to determine what cases there are that exist in the county. Some probably weren't affected as much as others, but it required those cases to be brought back to the court for review. And I think the numbers there were about 500 cases, so this would be a significantly higher amount of cases.
And you are an attorney. You're familiar with Commonwealth versus Sutley, correct?
Yes.
And what's your opinion on that ruling from 1977 based on what this bill is looking to do with retroactivity?
Well, I would agree with the way you summarized it previously. If it's a legislative change that becomes retroactive, the case basically says, that's not constitutional because it overrides a former judicial decision. So I would agree with how you're interpreting that this wouldn't be a legislative way to make a retroactive fix, that it wouldn't stand up.
I thank you. I thank all three.
Yeah.
I'm sorry.
I just like to say I'm also an attorney, just for clarification. But there's always room for legal interpretation. But I did address the point about the court backup in my testimony that it would be going through the parole board. I actually agree with her that it would create a backlog, and that's why we don't want that.
And I am not an attorney, but I am the former secretary of the Board of Pardons. And one thing I did notice is that when government wants to do something, they find ways to do things. And so I struggle to think that a backlog is a valid reason to not make these reforms that are so necessary. And I do want to make one final point. As we are in budget season, the Department of Corrections is the third largest expenditure from taxpayers. And we are currently experiencing a terrible staffing crisis in corrections. And I believe the additional appropriation that was asked for by the Department of Corrections was $100 million to cover overtime because we are in such a staffing crisis. They've recently reduced the age for recruitment to age 18, which I find hard to do. And so as we talk about how we're going to be spending our Commonwealth's money, I would like to think and explore and ask that all of you consider looking at second chance mechanisms that we know are going to protect public safety, but also allow our taxpayer resources to be directed in ways that actually protect public safety, as opposed to spending our taxpayer resources to keep people like Ezra, who was paralyzed in prison until he takes his last breath. So I do want to encourage, as the budget process goes on, that we consider felony murder reform, clemency reform, medical and geriatric parole as wonderful and proven options that could be a good result for there.
I just want to speak to the point of victims as well. Victims aren't a monolith. Ms. Didi is just as much a victim as anybody else, and there are victims who actually do believe in second chances. And even if you haven't been duly impacted, and if we're going to listen to victims' voices, I believe you have to listen to all of them, not just some of them.
And if I could just point out, then I think you're referring to families of the victims, because the victims do cease to be human when they are murdered. So it's not technically their voice, it's the voice of their loved ones.
Chairman, thank you. That's all I have. Thank you all for your testimonies today.
Thank you, Representative. Representative Kincaid, you're in order.
Thank you, Mr. Chairman. So I'm wondering, so I want to follow up on what Chairman Briggs was asking about. Can you speak to what the sentence is for third-degree murder?
Me? I wasn't sure if that was directed at me, I'm sorry. Yes, so the maximum sentence for third-degree murder is 20 to 40 years. The max is 40, and the minimum can't be more than half the maximum. But there are... Sorry.
There's a reality in which an accomplice ends up convicted of second-degree murder, and the primary perpetrator ends up convicted of third-degree murder.
Yeah.
In which case, the person who actually took somebody's life would have the possibility of getting out versus somebody who maybe just drove the car, which seems like an absurd result and sort of counter to the whole point of our justice system. And so I also want to clarify that the District Attorneys Association referred to victims in their testimony. So and referred to the families as victims. So I don't think that the previous correction is appropriate or necessary. But I also think that it's important for us to remember that when we're talking about felony murder, we are not, in fact, talking about the most violent people. We are talking frequently about their accomplices, and in particular about oftentimes women, and women who are in abusive relationships, who are under duress in terms of their participation. We're talking about a woman who's currently serving life in prison for picking up her boyfriend from a house where he killed somebody, and she had no knowledge of it, but she was convicted of felony murder. So these are the absurd results, that life in prison for felony murder, for second-degree murder, which is considered a more severe punishment than third-degree murder. But in reality, we can absolutely have a situation where somebody who has actually pulled the trigger can end up with a possibility of getting out while their accomplice, while their driver doesn't. So, and you know, it's not a hypothetical. So I think the reality is that we are already practicing an absurd result in our criminal justice system, and we need to change it because we are putting people in prison for life and allowing people who have actually taken lives to get out. That seems a little backwards to me. And I think that we can do better, and we should be doing better. Thank you, Mr. Chairman.
Thank you, Representative. Any other questions online in the room? I do want to thank you all for sharing your time with us and your expertise. The hearing is coming close to a close, but I do want to kind of echo the comments that Representative Kincaid just said about the absurdity. When we legislate and it's quickly when we try to go the emotional route and try to scare people into making change. That's not the best way to advance public policy. I do appreciate all the stories that we heard today. Roxanne, the stories you shared, Celeste, the stories you shared, and also Dawn's story about her son. It is challenging when we are trying to fix absurdities. And I agree that this is not the type of Commonwealth I want to be in, where just the broadness of second degree is what we were left with, and we're just going to try to scare folks into making a change. So I will continue to advance this. I think this was very helpful to hear from so many folks. I do want to thank you all for sharing your time and expertise. If Representative Rigby has any closing comments before I adjourn.
No, I just thank you. I thank for our testifiers, all of them today. And again, the stories are well told, and we can't make bills and legislate on emotions, and we'll look at all of this, and I'm sure we'll move forward. But I thank you for allowing me to sit in the chair today as a chair, and hope I don't have to do it again.
I would welcome you to sit next to me any day, Mr. Rigby. Thank you. This meeting is adjourned.